Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer and I'm an Extension Legal Specialist and Senior Faculty Specialist in the Department of Agricultural and Resource Economics at the University of Maryland. And today we're going to be back, and we're going to talk about, a follow-up to an episode from about 2 weeks ago, looking at a potential class action lawsuit that was filed against Perdue Farms involving a poultry grower in South Carolina, or former poultry grower in South Carolina. And this one, we're going to look at the fact that in answering the complaint, Perdue Farms made some arguments for reasons why some of the claims should be dismissed. And the court has recently ruled on that motion to dismiss. They ruled late last year on the motion to dismiss. So we'll talk about what some of those arguments were and how the court came out on them. So if we look back, a federal district court in late 2022 ruled on a motion to dismiss claims filed by a former grower at Perdue Farms, arguing that the grower was not an independent contractor, but an employee of Perdue Farms. This action was one of two filed in 2022, making very similar claims. The other one was against Amick Farms. In this decision, the court denied several of Perdue's arguments, but did ultimately dismiss two claims. And I'll post in the show notes where you can find the decision in this case. I don't have a copy of the opinion, but you can find it based on the information I will provide you. So let's talk a little bit about the background. Like I said before, I recorded an episode. I blogged on this recently. I'll provide most of the background in the show notes where you can hook up to that former episode or that blog post and look at what's going on and talk about it. But the essential background is that we have a South Carolina former poultry grower who sued Perdue Farms in Georgia in federal district court, claiming that Perdue had misclassified him and other growers as independent contractors when they should have been classified as employees, failed to pay a minimum wage under the Fair Labor Standards Act, and violated the Packers and Stockyards Act in several state law claims involving fraud, breach of contract, unjust enrichment, and negligent misrepresentation. Perdue filed a motion to dismiss for failure to state a claim for some of the claims, including the Fair Labor Standards Act claims, partially state law claims, and the Packers and Stockyards claims. So let's look at that opinion real quick. It's important to note, for those unfamiliar with a motion to dismiss for failure to state a claim that typically claims will survive if the complaint states claims for relief that on its face appear plausible and alleges sufficient factual matter. The court highlights that a complaint may survive even if a savvy judge believes recovery is remote. The complaint will survive a motion to dismiss for failure to complain, often in those cases. So this is not a magic bullet. We often have to proceed past this to allow claims to get a little more evidence to determine if they should proceed or not. So let's look at the Fair Labor Standards Act claims first. Perdue argues that the federal district court in Georgia does not have jurisdiction over Perdue for claims by potential plaintiffs outside of Georgia. However, Perdue is also arguing that even if the court has jurisdiction and the court agrees that the Fair Labor Standards Act covers the plaintiffs, then they fall under the agricultural exemption in the Fair Labor Standards Act. Looking first at the jurisdiction argument, the court basically decides it's too early to decide before potential class members have attempted to join. The case hasn't even been certified as a class action yet. Perdue points to the poultry producer agreement that all growers sign that has a forum selection clause. This forum selection clause states that the grower will bring suit in the state or federal court in the farm's county. So basically, if you're a grower, you've already agreed upon where these cases will be heard. The court will need to determine first if all future class members had this forum selection clause in their agreement, and will wait until plaintiffs opt into the litigation to make this determination. So at this point, the court's not going to rule on this jurisdictional or the lack of jurisdiction question. The court next turns to the arguments that the growers would fall under the agricultural exemption within the the Fair Labor Standards Act, typically determining if this exemption applies applies requires extensive fact-finding that needs to be done as the case moves forward. Therefore, the court needs more facts to answer the question and whether the exemption it's currently not ripe for review. So the court's just going to wait to make a decision later on this question. Next, the court turns to arguments made by Perdue that the state law claims of negligent misrepresentation and fraud require heightened pleading standard under the federal rules of civil procedure. This is basically Federal Rule 9b. This requires this heightened standard for those claims based on fraud. So we have to determine if both of the negligent misrepresentation claim is based in fraud under Georgia law. So under Georgia law, negligent misrepresentation is based on tort law and not fraud. Therefore, the case, at least for the negligent misrepresentation part, that heightened pleading standard does not apply. Turning to the fraud part of the complaint, the plaintiff meets most of the requirements. The plaintiff has outlined some of the statements and omissions from the poultry producer agreement that could be fraudulent. They've alleged that Perdue drafted the language in question. The plaintiff has alleged that Perdue profited off the misrepresentations that were the proximate cause of the plaintiff's damages, but the plaintiff never explained he discussed the poultry producer agreement with and any misrepresentations made by that person. At the same time, the plaintiff references broad portions of the poultry producer agreement, but does not cite specific instances of fraud in that agreement. The court dismisses the fraud claim without prejudice to allow the plaintiff time to amend the complaint to meet the heightened standard for fraud. Perdue's arguments for the plaintiff not having standing to bring state law claims for growers outside of Georgia. The court views these arguments as premature. Therefore, before the class is certified, the court must only determine if the plaintiff has standing. If the plaintiff has standing, and Perdue denies the motion to dismiss on that case. Turning to the last argument, the court agrees with Perdue that the plaintiff's Packers and Stockyards Act claim must fail because the plaintiff has not alleged any harm to competition or requirement when bringing one of those charges. So accordingly, Perdue's motion to dismiss is granted on this claim. So two claims are dismissed, one without prejudice, so it could come back. So why do we care about this? This is one of two cases filed last year, claiming that growers are company employees and not independent contractors. Although several of Perdue's arguments were denied at this stage, it doesn't mean that the court may not later revisit some of these after more of the record is developed. Therefore, we'll have to keep watching these cases to see how it progresses, to see if it gets certified as a class action and if claims are dismissed as a record is developed. Again, thank you for listening. If you have any questions, thoughts, ideas on future episodes, you can email me at lgoering@umd.edu, or you can tweet me. Find me on Instagram at AgLawPaul. Thank you again for listening and enjoy the rest of your day.